Nancy Gibson 5769 says, seems these traffic, I guess she's trying to say traffic stops. Seems these traffic stops take way longer than necessary. Takes a while to create a crime. What a shame law enforcement has become. Well, Nancy Gibson, my answer to that is that the police need, there's an acronym out there that was created by, I guess, different lawyers and judges and law enforcement, or maybe it was created by just this one channel I know called Blue to Gold Law Enforcement. Anyway, there's an acronym out there called CREW, CREW, which stands for consent, recognized exception, exigency, or a warrant. So I'm not sure if these particular police officers got consent or if there was a recognized exception, or exigency or a warrant. I'm assuming there was probably a recognized exception, such as they could smell marijuana, or there was consent, which happens a lot of time out here in El Paso County, Texas, where a lot of people just go ahead and say, okay, officer, go ahead and search my vehicle, because either they don't know the law or they just happily waive their rights. For whatever reason, that's how people are here. They waive their rights and they consent. So the police don't even need to worry about any of the legalities of the Fourth Amendment at all at that point. But yeah, in the case or in the event that this is a probable cause search where there was no consent, I wanted to just briefly get into the legal doctrine and legal concept about vehicle searches, which is dealt with by the U.S. Supreme Court case from approximately 100 years ago, which was called CARROLL versus United States. And that's if the police needed probable cause for the search. There's a very good chance that it might not even need probable cause at all, because this particular motorist might have just consented, which many motorists in El Paso County do, like I said. So I don't have all the facts about this particular traffic stop, but I do have some basic assumptions about what happened. And that is, it was either consent or probable cause. I doubt that it was because of exigency or because they had a warrant. That's pretty rare for a motor vehicle search, to search it because of exigency or because of a warrant. It's usually because of consent or because you have a recognized exception, which means that you have probable cause, which means the officers do not have to go to a judge to get a warrant. They just, based on their training and experience and based on articulable facts, that they can then search. And so that's where CARROLL versus the United States, comes in, is that that's the Supreme Court case from approximately 100 years ago. Ironically, it was because of booze. It was because of the Prohibition era in the 1920s and 30s that it was from, which is back when the United States had illegalized alcohol for a short period of time. Now, fast forward 90 or 100 years to the future, we have a law on the books, or a Supreme Court doctrine on the books, that was actually created out of the prohibition of alcohol, which is now being used to search vehicles for marijuana. So it's kind of weird how things work out, but that's the way it is here in this country. All right. Thanks for your comment, Teresa. And thank you for being a viewer, or if you're a subscriber, thank you for that. Thanks for watching Horizon City News. I'll be in touch, guys. And let's just watch this quick video here and just get a brief overview of CARROLL versus the United States, 1925. It's from approximately 100 years ago. All right, guys. I'll be in touch. Happy New Year. Thanks for watching Horizon City News.
Anyways, yeah, man.
Well, speaking of New Mexico, I know you got to go, but did you see the video I just put out?
No, I haven't caught it right now. How long ago did you upload it?
I put it up last night. It was the local police department where I live, and basically they were shaking down.
They got arrested for, I think, was he recording?
I'm sorry?
Well, what? Some guy got arrested, right?
No, thankfully they let him go. I want to believe it's possibly because of my camera.
Yeah, it's very, because I did see, I saw like the beginning of it. I was at work, and then I didn't really get the chance to watch the whole thing. but I know that some guy was like about to get arrested. So you interviewed.
Right, I know. It's a long video. It's 23 minutes long, I know. But if you do watch the thing from end to end, whenever you get a chance, you'll see that eventually they let the guy go. And his girlfriend was very emotionally distressed. She was there. I mean, that's a real woman right there. She was there in the cold and waiting for him. She's not even his wife. She was his girlfriend, and she was just there and, like, seeing if they might let him go. And the police were nice enough to still talk to her, which they don't even have to do.
Yeah, for real.
Now, I'm not trying to put a crown on my head, but I believe that the fact that I showed up with my camera might have changed some things.
Yeah, no, yeah, it's very likely, man, because, you know, they're not expecting to get recorded. You're lucky that they didn't even just try to arrest you, bro.
Well, that's a long story, and I'll tell you this. In Horizon City, Texas, I will put a crown on my head. The Horizon City, Texas Police Department, that's my fucking town, and they know that if I'm around, they will get recorded.
The date was September 29th. Mr. Stafford was in an apartment in Grand Rapids, Michigan. He was there to purchase 3 cases of whiskey from John Carroll and George Kiro. They negotiated and agreed on a price, $130 per case, and Carroll and Kiro left the apartment to pick up the whiskey. They returned a short time later and told Stafford that the supplier wasn't in, and promised they would deliver the whiskey the next morning at 10 o'clock. The next day came and went. Carroll and Kiro never showed. Could it be that they suspected that Mr. Stafford was actually a federal law enforcement agent? Maybe so, because the year was 1921. The National Prohibition Act was in effect. The National Prohibition Act made it a crime to possess, sell, or transport liquor. Stafford's true name was Fred Cronenwett, and he was the chief prohibition officer in that federal district. Agent Cronenwett's investigation of John Carroll and George Kiro led to the Supreme Court's landmark 1925 decision in Carroll v. United States and the birth of the mobile conveyance exception to the Fourth Amendment search warrant requirement, also known to law enforcement officers as the Carroll Doctrine. While he was at the apartment that evening, Agent Cronenwett identified the car that John Carroll and George Kiro were driving as an Oldsmobile Roadster and took down the license plate number. On October 6, 1921, a few days after Mr. Carroll and Mr. Kiro were no-shows, Agent Cronenwett was out on patrol with another agent. They were patrolling the road between Grand Rapids and Detroit, Michigan. Prohibition agents patrolled that road because it was one regularly used by bootleggers to transport whiskey. Agent Cronenwett saw Carroll and Kiro drive by in the Roadster. Agent Cronenwett and the other agent he was with initiated a chase, but they lost the car. A couple of months later, on December 15th, luck was with Agent Cronenwett again. While on his regular tour of duty on the same road, he spotted the Roadster and saw Carroll and Kiro inside. The agents again initiated a chase, and this time were successful in pulling the car over. Mr. Carroll, confirming that he had suspected Agent Cronenwett's true identity, got out of the car, greeted Agent Cronenwett by his true name, Fred, and offered him $10 if Agent Cronenwett would let Carroll and Kiro go on the strength of the promise that they wouldn't engage in the unlawful activity again. Agent Cronenwett declined the money and the offer. The agents searched the car, and behind the upholstery of the rear seat of the Roadster, they found 68 bottles of whiskey and gin. Mr. Carroll and Mr. Kiro were indicted and convicted in federal district court for transporting liquor in violation of the National Prohibition Act. 1 bottle of whiskey and 1 bottle of gin were admitted into evidence by the government at their trial. Carroll and Kiro appealed, contending the search of the automobile and the seizure of the whiskey was a Fourth Amendment violation. The Supreme Court looked to an amendment to the National Prohibition Act in making its decision. The amendment provided that agents engaged in the enforcement of the act who searched a private dwelling without a warrant could be charged with a misdemeanor. But agents who searched any other property without a warrant could be charged with a misdemeanor only if the search was malicious and without reasonable cause. The Supreme Court recognized in reviewing that amendment that it was Congress's intent to allow warrantless searches of other property, such as vehicles under the Act, so long as those searches were supported by reasonable cause. The court found the distinction between a warrantless search of a dwelling and a warrantless search of a vehicle to be consistent with the Fourth Amendment requirement that searches be reasonable. Because the court recognized vehicles are mobile and can be moved quickly out of the jurisdiction where a warrant could be obtained, and then evidence or contraband in that vehicle would be out of law enforcement's reach. However, the court held that law enforcement officers must have probable cause to believe the vehicle contains contraband or evidence of a crime. In the case of Agent Cronenwet and the other prohibition officers, the courts found that probable cause did exist. The officers were patrolling a highway that, based on their training experience, they knew was often used to transport liquor. The information they'd previously obtained about John Carroll and George Carroll gave them probable cause to believe that the Oldsmobile Roadster and its occupants were engaged in the illegal business of bootlegging. The Carroll decision created a judicially recognized exception to the Fourth Amendment warrant requirement. But it's important that law enforcement officers know and abide by the requirements of the mobile conveyance exception. First, officers must have probable cause to believe that evidence of a crime or contraband will be found in the mobile conveyance. When is a conveyance considered a mobile conveyance? A mobile conveyance is one that is presently operational, one that can be rendered operational with only a minor repair, such as changing a flat tire or replacing a dead battery. There's no requirement that the vehicle be currently in operation. What's the scope of a search under the mobile conveyance exception? It's the same as the scope of a search that an officer could conduct if the officer had obtained a warrant issued by a judge. The officer can search any place within the mobile conveyance that the evidence or contraband that the officer has probable cause to believe is in the vehicle might be found. In the case of a vehicle, this could include the passenger compartment, the trunk, the glove compartment, the console, the door panels. Also, it's important for officers to remember that the mobile conveyance exception is not limited simply to automobiles. Mobile conveyances can also be boats, airplanes, motorcycles, or recreational vehicles, for example. The mobile conveyance exception created by the court in Carroll v. United States gives law enforcement officers an important tool that they can use in executing their duties. But remember, the articulable facts that a law enforcement officer must offer to justify a search under the mobile conveyance exception must be the same as the facts that that officer would be able to present to a judge and obtain a search warrant. And officers should also remember to conduct the scope of their search in a way that's reasonable under the Fourth Amendment. That is, limit the scope of the search to those areas in the mobile conveyance that the contraband or evidence of the crime could be found. I'm Teresa Hoyt, and this has been FLETC Talks.